But this is the case note from January 6th. Case staffing regarding safety services in the home at DFS South Office. Present was DFS in-home specialist, no name.
Let's go with Eggleston versus Stuart, case number A16748919-C.
Your Honor, Ms. Armeni had to run to 10D. If you could trail it for a few minutes, I will text her.
Okay, that's fine. It's just the next one will probably take a little while, that's all.
I'm sorry.
That's all right.
Thank you.
Well, I'll take this one first.
Okay.
Paola Armeni, is she
Yes.
here?
She is.
There she is,
Thank you.
okay. I'm sorry, it's just that the last matter involving the other parties, it's gonna take a while, I think, so.
And I apologize, Your Honor. I had to go up to Judge Sturman's courtroom too for 9:30.
Let me call the case, and that's Eggleston versus Stuart, case number A16748919-C.
Good morning, Your Honor. Paola Armeni on behalf of Mr. Eggleston.
Good morning, Your Honor. Felicia Galati for Clark County and Georgina Stuart.
Okay, and counsel, I guess we had a little bit of a misunderstanding in terms of filing. It looked to me, when we were going through things, that I had granted, because it was unopposed, the motion to file the motion, or the opposition or something under seal. And that's why there was no motion to amend the first amended complaint put on, because the motion that I granted was the motion to file the motion to amend the first amended complaint under seal. Does that make sense?
Yes, I think so.
I think you granted their motion to seal.
Right,
Yes,
but
correct.
the actual motion wasn't granted.
No.
Right.
No. Oh, it wasn't, Your Honor?
I'm sorry.
Next try.
Okay, and it wasn't, and then because the first motion was withdrawn, that was the one that had the hearing date. That's why you didn't have a hearing date on this one. Does that make sense?
Sort of, yes.
Okay, well, anyway, I'll listen to your motion to amend the first amended complaint. I understand you want to add parties, Ms. Armeni, and the concern I have, we got a trial date of January.
Right.
And it's almost like motion to amend complaint and motion in anticipation of defendants wanting to continue trial because they're gonna need more discovery.
And candidly, Your Honor, obviously, anytime you move to amend a complaint, there's always going to be some delay. And I don't think I can stand in front of the court and tell you otherwise. What I can tell you is that the 3 people we are seeking to add, it did not become clear to us until we started getting further. So everything started with Mr. Eggleston at this meeting that occurred on January 5th of, I don't remember, 2015 now. And so the unity note that we had was not very clear. In fact, I didn't even know who certain parties were within the unity note. And as we started going through discovery, we said, okay, we need to depose these people. And that's what we did from January, I think, to April, is we deposed all these folks and got more information. We got more emails that were discussing. We got 2015 emails in February of this year that discussed what was going on at that meeting, because when you look at the unity note itself, it wasn't clear. And then it became abundantly more clear, okay, what was going on in this meeting was a reverse, and what the course was what was going to happen with Mr. Eggleston and his children, which was essentially the removal, because again, the unity note doesn't state that. So we could have, I guess, filed it in January, but my concern was, we would have been coming back to the court multiple times for multiple defendants, because based on scheduling, I mean, we scheduled all of them in that time frame. But it didn't make sense for us at that point to bring it to the court after the first depot without taking these other depots, because we anticipated that after those depots, we may have more people to add. So and the defendants don't really address, they broadly say bad faith, dilatory motive, and undue delay. I don't think there's anything to indicate that we want to extend anything on purpose. There's no strategy there for us. We want to get this going as much as everybody else. We just learned the information and brought it to the court pretty quickly after we were able to assess that these folks should have actually been defendants themselves, because as the court knows, Mr. Eggleston represented himself pro per initially. And so when we came in, that's when we did a deep dive in the case and reviewed everything and started taking these depositions. So these are essential defendants that absolutely should be added. I think they're unique in that I can tell you, I'm gonna make an assumption here, I may be wrong, that 2 out of the 3 will be represented by Ms. Galati. Their expert, who's already provided an expert report, his whole expert report is on the policies and procedures of DFS. So as it relates to new defendants coming in, I'm not sure, he may have to do maybe a supplement, but the majority of what he's done would apply to all 3 of the defendants. You know, the Miss McKay would probably be the only one I can't speak to, because frankly, she showed up at her own deposition with different counsel than Miss Galati, and so I don't know what their position would be, and that's sort of the unknown for us. But as far as the other defendants, this would be, I think, the delay would be minor based on the fact that they would be represented by the same counsel who's had the case almost from, not from the beginning, but fairly thereafter, knows this case very well. It's the same issues. We're not dealing with any new claims or any new issues. It's just, and their defenses, frankly, can't be much different. They all made the decision together to remove these children. So for those reasons, although there would be a delay, we don't think it would be significant enough to not allow the amendment to take place.
Counsel?
I completely disagree, Your Honor. Everything was known from day one. The plaintiff knew on January 7th, not the 5th, January 7th, 2015, when Ms. Stewart went to the home, that he had certain options, and that the supervisor had overridden him being in the program and or providing in-home services. That was January 7, 2015. He filed 2 complaints, the original complaint and then the First Amendment complaint. Both of those pleadings allege those facts because he already knew those facts. So the original complaint was filed on December 30th, 2016, 6.5 years ago. The amended complaint was filed on August 10th, 2017, 5 years, 10 months ago. That's a long time, Your Honor. That's way beyond the cases that you have that have been cited in the briefing.
I was gonna say, this is my 3rd oldest case.
Okay. Anyway, so it's been a substantial period of time. They knew what the facts were, but it's not just that. Ms. Armeni says they didn't know until the emails came the identity of certain people. That's absolutely not true. You have the Unity notes, which she gave you and we gave you as well, that indicate there was a staffing on January 6, 2015, and it lists Mary Atterbury, and it lists Sharon Savage. Those are 2 of the people she's trying to add. They got those, the plaintiff got those in the county's initial disclosure that was issued on April 8, 2018, 5 years and 2 months ago. There was no reason for them to wait. In addition, Ms. McKay is in those Unity notes as doing various things, and her identity is indicated as manager. There was no reason to wait. And this delay is theirs. It causes us a burden and additional fees and costs. There has been no decision made as to who's going to represent Ms. Atterbury and Ms. Savage. They have the right to choose, and that's not going to happen unless and until Your Honor makes a decision that the motion to amend is granted and they receive the pleading. So that decision has not been made, but that doesn't change it, because at the time I was doing the work for Ms. Stewart, I'm not thinking about Ms. Savage, I'm not thinking about Ms. Atterbury, I'm thinking about Ms. Stewart. So everything is going to have to be looked at again. All the thousands of pages of documents we've disclosed, all the written discovery we've done, all the depositions we've taken. Questions weren't asked about certain individuals because they weren't in the case. Plaintiff's deposition, the Stewart's deposition, and everybody else. We took 12 depositions in this case. There is no excuse for them waiting until the scheduling order deadline to add the defendants. When they start to take depositions, they should have added them before that. Then we could have done it all at once. Now we're going to have to redo everything. And yes, the expert's going to have to look at everything again, and he's going to have to look at these different defendants and make a decision. And Ms. McKay, I mean, she's not, she's a separate person. She has her own attorney. He's going to have to get an expert. So all the deadlines are going to have to be continued, not just the 3 that have passed already, but all the other deadlines as well as the trial date. There is no basis to amend this complaint because there has been undue delay. There's no doubt about it. They knew from day one, on the date the incident occurred. They knew from the pleadings that were filed. They knew from the Unity notes. which they got on April 4th, 2018. That was a long time ago. There's no excuse for waiting this long. The motion should be denied.
Well, Your Honor, Ms. Galati represented the two, Ms. Atterbury and the other, Ms. Savage at their deposition. So she was well aware and looking for issues for them. But this is the case note from January 6th. Case staffing regarding safety services in the home at DFS South Office. Present was DFS in-home specialist, no name. This specialist, who I guess I'm assuming is Ms. Stewart, Mojave Mental Health, we don't have a name, Sub Mary Atterbury, Sharon Savage, and Clint Holder. We had no idea who Sharon Savage and Clint Holder was, and frankly, Ms. Stewart's supervisor was actually Felicia Tucker at the time when all this happened, and Ms. Tucker's name wasn't on anything, so it wasn't as clear cut as it may appear. There were multiple supervisors throughout all the paperwork because the lead supervisor wasn't even present. So Ms. Stewart was going to whoever she could. That was the unity note that I just read the court that we're working on. It doesn't explain positions. It doesn't even explain that they were speaking about the removal of the children. It was through the emails that we got in February 2023 that we're learning that, oh, we were asking for rent and then we decided to pull the rent back because now we know we were removing the children. There were emails where Ms. McKay is saying, hey, this seems like a good family that would work well with the Mojave Mental Health. Let's try that. That's all stuff that we received in February of 2023 where there's clarity as to more of what's going on in this meeting, because I submit that note alone doesn't provide any guidance as to what was happening, what decisions were made in that meeting. It's just a statement that a meeting was made, and it's through the discovery process and finally through these depositions that we were able to finally ascertain what exactly happened in that meeting and why did that meeting go the way it did. We still don't know who the Mojave mental health person is that was in the meeting, and that's after all these depots and after all this discovery. So there's still gaps missing based even on the information that we've received.
Your Honor, we gave them the org charts. They knew who everybody was.
I will let you finish, but it's motion, opposition, reply.
Sorry.
There's nothing to respond to that.
Okay, counsel, at this point, I'm going to deny the motion to amend. It's coming at the heels of the trial, which I am not going to continue again. And I know what's going to happen, is that the defendants, once they are served, and answer or file we may even have motion practice for all I know. I am denying it. Obviously, you're free to file something separately if you feel the need to, but I've got to do this trial. It's one that I inherited, as you know, last year. And I'm also concerned, I know that you guys had an appeal, and it looks like the appeal was stayed the case for a little bit, but not long, maybe a year and 3 months, something like that.
I think, Your Honor, the order to dismiss was on September 7th of 2018. The Supreme Court ruled on September 23rd of 2021.
Okay, so we've got 3 years?
I believe it was about that.
I don't have those in front of me.
That's what I'm looking at, my timeline.
18 is right for the initial order to dismiss, and I can't recall the date for this.
Yeah, I have the Supreme Court ruling on September 23rd of 2021, because then we filed our appearance on November 29th of 2021.
Okay. What I might need you guys to do is make sure we're not running afoul of 41E, NRCP 41E. Because, I mean, without taking any stays, you know, with the Supreme Court, this is a 7-year-old, almost a 7-year-old case. It was filed, December of 2016?
16, yeah.
Yeah, December 30th of 2016. And obviously, if we've got a 3-year stay in there, then we're around the 4-year mark. And I think you get some time after appeals come back, but I think that's only 3 years, isn't it?
Well, I don't think they can blame you for the time the case was up at the Supreme Court.
Right.
So that's a good period of time. I just
Right.
don't have the exact dates. And I don't know what the time is after they do returns.
Okay. Well, it's something to think about anyway.
Okay.
Okay, will you prepare the order and pass it by?
Yes, of course.
Okay.
Thank you, Your Honor.
Thank you.
All right, thank you. Okay, let's go to the last matter.